for the delayed start. I declare open the fifth hearing of the Senate Economics References Committee's inquiry into the post-GFC banking sector. This inquiry was referred to the committee by the Senate on the 14th of March 2012 for report by 31 October 2012. The committee has received over 150 submissions which are available on its website. These are public proceedings, although the committee may determine or agree to a request to have evidence heard in camera. I ask everyone to ensure that they've switched off their mobile phones. I also ask photographers and cameramen, if we have any, to follow the instructions of the committee secretariat and ensure the senators and witnesses' laptops and personal papers are not filmed. I remind all witnesses that in giving evidence to the committee they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, also be made at any other time. A witness called to answer a question for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly and into the microphones to assist Hansard to record proceedings. I now welcome Mr Mark Engelbert from Taylor Woodings. The committee has received and considered your submission. Mr Engelbert, would you care to make an opening statement?
Thank you. Yes, Senator Bushby and members of the committee, thank you for inviting me here today to appear before the committee. I'm a partner in the firm Taylor Woodings, a chartered accountancy firm who practice in corporate recovery, restructuring and corporate insolvency. I've worked in this area for 15 years. I appear before you as joint and several receiver of three entities: Lighthouse Beach Holdings, Butler Constructions and National Hotel Property. In our written submissions of the 8th of October, we've attempted to respond to the issues raised by the committee as a result of the submissions, both oral and written, by Mr Sean Butler. In the interest of time, I don't wish to repeat everything in those written submissions, so I'll cover things at a high level, but maybe refer you to the submissions. But I would like to make a few overview observations. First, I deny that I or anybody else did anything to try and prevent Mr Butler giving evidence to the committee. The committee would have seen my email of the 7th of August. In that email, I did not in any way suggest that Mr Butler did not give evidence before the committee. I'd also like to say some things about the receiverships of the three companies. The receiverships were very complicated. The Lighthouse Beach Resort had to be managed and marketed for sale. This took a great deal of time and effort. The National Hotel in Fremantle was only half owned by the entity to which I was appointed. The building was incomplete, it was not completely repaired, and the property had to be marketed and sold despite those difficulties. Again, that process took time and effort. In addition, over and above the time and effort involved in the above, we dealt with Mr Butler's many queries which he requested answers to. Mr Butler was not ignored. My office, or my solicitor's office, tried to respond to the many issues raised by Mr Butler. This was very time-consuming. Finally, the receivers and managers denied the several allegations that Mr Butler has made to this committee. They are dealt with in our submissions. At all times, we acted professionally, as required by law and the Code of Conduct that applies to the conduct of the receivership of the companies, and in an efficient and appropriate manner. I ask that my evidence be given in camera for the reasons set out in paragraph 6 and 7 of my submission, as sent to you on the 8th of October.
Okay, thank you, Mr Engelbert. In terms of going into camera, what I propose to do is to give the committee an opportunity to ask some general questions. One of the reasons why we've called you along is clearly the situation involving Mr Butler has provoked us to ask you in particular, but there are broader issues in terms of how insolvency practitioners approach these types of issues, which we're interested in as well. And I guess Mr Butler meant that you were the ones that we invited along to do that. It gives us an opportunity to examine that, and certainly we're very happy to move into camera when we discuss the specifics of that. But if you're happy with it, what I intend to do is initially just ask some general questions about insolvency in the context of banking issues in an open hearing, and then before we move into camera. So you're happy with that? So you're nodding?
Happy with that.
Yes, thank you. Okay, well, just a couple of questions first. Can you outline, in the context of a secured property involving banks, can you outline the standard processes by which receivers are appointed?
They would be appointed. I can't talk about the process that the bank goes through,
Right.
but we would be appointed pursuant to their security. You're talking about the steps that we would then take once we were appointed?
No, I'm more interested in how you... on what basis do you understand that you've been appointed as a receiver for under one of these secured properties, over one of these secured properties? How do you know that you've been appointed?
The bank would provide us would speak to us, provide us with documents in relation to the appointment document, which we'd review, an indemnity.
So that'd be a court document?
No, a document prepared by themselves.
Okay.
So they don't. Sorry, it's not a court.
Okay,
process.
so that's what I'm trying to get to. So,
Yes.
on the basis the bank just says to you they've decided to prepare the documents, which then effectively create a receivership over the companies involved.
Correct.
And then on the basis of that, you then have legal entitlement to go in and do what you do?
Yes, whatever is allowed for under their security documents, and obviously pursuant to the Corporations Act as well.
And is there any opportunity or notice that's required to be given to the companies involved, as far as you're aware?
That's the matter that would be dealt with by the bank before we would be appointed.
Okay. And so the bank draws up those documents, provides them to you. As part of the handover of the receivership, would they provide you with specific instructions as to how they would like you to proceed?
No.
I note in your submission that you say that once you're appointed, you are independent. In the particular instance, you're independent of Bankwest.
Yes.
So they just provide you with a document saying you're now a receiver.
Correct.
The property over which you have control. And it will detail that.
Yes.
But then it's up to you to employ your skills and experience to try and manage that company through and achieve the best result for all creditors.
Yes, correct. Yep.
Okay. Now, if the company to which you're appointed to act as receiver has complaints about the way that you're doing the job, are there any avenues that they can use to seek redress?
Various avenues. The FOSS process.
That only applies to up to a certain monetary limit, though, doesn't it?
Yes.
Yeah.
Yes. I suppose ASIC discussions with ourselves to try and resolve the issues. Yes, maybe as we saw in the case we'll talk about later, to actually contact the bank directly. Okay.
Are there any legal requirements or professional requirements or avenues for external dispute resolution?
There's also the Insolvency Practitioners Association, but that's more of, it doesn't have a process for disputes.
Yep.
The main issues are with the code of professional practice that we have to abide by, and also being chartered accountants, which is bound by codes there as well. So it's kind of the main way of it regulates ourselves, really.
Yeah. Now, quite clearly, in this particular case that we'll look at in more detail later, but in other cases as well, the individuals involved with the companies that go into receivership, and understandably, and it's obviously an emotional thing in a lot of ways, but they feel that it's not a particularly transparent process and often feel aggrieved. And I guess that's something you deal with day to day. But on the basis of your 15 years' experience, do you think that there's scope for making the process more transparent so that those who are impacted can feel or have a greater degree of confidence that things are being managed as well as you say that they are in your submission?
I think there's got to be a balance. That we're trying to do a job, and it's not necessarily the job that they want to do, that they want us to do, and having a process where maybe we're giving commercially sensitive information is pushing the balance too far. So I think there's the avenues. Our costs are available through ASIC. Our costs and receipts and payments are available through ASIC every 6 months. We're appointed by our appointor, by the bank, and our primary responsibility is to the bank.
So to your appointor,
yes.
Not to other creditors, to the creditor that appointed you.
As a secondary
Yeah,
level,
that's right, to other creditors as well. But you do have a primary responsibility.
Yes.
So if there were a number of secured creditors who had the legal right to be able to appoint a receiver, the first one in effectively gets the best call?
In terms of the flow of cash, the flow of funds, it would go in order of their security, the ranking of their security.
So, of the security of the creditor that actually called in the receiver, I'm just clarifying.
Yes.
I know there is
yes.
Yes.
Yes. Yeah. If you were appointed by the second chargee, the flow of money would go to the first chargee first.
Okay, and then so there is the normal order. So that that's what I thought it was the case, but the way he indicated that, I thought it might have been otherwise. Okay, I might hand over to Senator Williams to ask some general questions now, and then
thanks, Chair.
Senator Cameron, you have some general stuff.
Yeah. Thanks, Chair, and we'll go into some more details. Mr. Engelbert, Section 420A of the Corporations Act, are you familiar with it?
Yes.
Could you just, for the record of the committee, explain Section 420A, please?
It's obviously it's in the Corporations Act, and it deals with receivers obtaining market value for an asset, or if there's no market value, the best possible price, but it's normally the first limit applies. And the case law around that generally deals with it. A prudent receiver should obtain valuations, should follow a proper process that would result in getting the market price. Examples would be using an appropriate sales agents, marketing, and having a valuation. And it's to me, it's designed to benefit both the bank and the owners, that you get the best you can.
What would ever happen if someone, an insolvency practitioner, was found guilty of breach of 420A by ASIC? Is there any stipulated punishment, or is it referred to some other court, or what would happen if someone was found to have breached Section 420A?
I don't know the procedure within ASIC, what they might do.
Yeah, fair enough. Yeah. When receivers are sent in by a bank, someone who's lent the money to a business, whatever the condition, can you sell off assets that the bank, the financer, does not have a mortgage on, or no one has a lien on?
If it's not covered by the bank security, then no.
So a receiver can never do that?
Correct.
So if a receiver was sent into a farm, and the farmer worked on the farm while the receiver was there, and the farmer harvested the wheat and put the wheat in a silo or grain shed, and the receiver had or the bank had no lien on that wheat, and the receiver had no lien on that wheat, that means that receiver can't sell that wheat? That
would be on your scenario of the bank had absolutely no interest in it, then that would be my understanding.
How do you define interest in it if the bank had not got the farmer to sign a lien on their wheat, for example? If there was no lien, and no mortgage, no bill of sale, whatever on that wheat, then the receiver has no right to sell that wheat.
That would be my understanding. Yes.
Yeah, good. Yeah. That's about all the general questions I have, Chair.
Okay, thank you. Senator Cameron, general questions?
Well, there are general questions, but I've got some questions.
If in relation to the particular matter of Mr Butler, we'll deal with them in camera, but if they're about insolvency in general, then we can deal with those now.
Okay. Yeah, some of the general questions, I think. I've got some general questions. And it is in relation to the receivership that you had on these three companies. You've provided a whole range of documents. I'm not going to go into anything that should be in camera here. About 43 documents, 43 documents. Is there any other documents that we should have? Because it looks to me as if you've gone into more detail than most other witnesses in providing documents. Is there any other documents related to these three receiverships that you haven't provided?
There are basically documents which are a repeat of what's in here.
So this pack, I don't know, 40 mil thick, is all the relevant documents in relation to those three receiverships.
In relation to Mr. Butler's submission.
Yeah, so you did a document search and we've got everything, have we?
Except for where Mr. Butler, where we have documents which refer to a repeat of the same issues.
Did you get any legal advice on your position on these receiverships?
Yes.
Is the legal advice included in these documents?
No.
Is the legal advice available to the committee?
It's be subject to legal privilege.
Yeah, I know they're subject to legal privilege, but is there any reason why you've given us all these documents but none of the legal advice that you've got? Is there something in the legal advice that's a problem to provide the committee?
There's nothing within them that would be a problem.
Well, can I ask you to provide the legal advice documents to the committee?
Could I ask take that on notice?
Of course.
Yep.
Of course.
Yep.
I'm simply asking, you've gone into a lot of trouble to provide all these documents and it's not the complete picture without the legal advice. And if there's something that is commercially in confidence for the company or legally confidential, then I'm not, I understand the position, but you should tell us that. Okay? On general issues, the cost of doing a receivership. Was this a more expensive receivership in terms of your company's involvement? Did it cost you more to do this receivership than normal?
That'd be something I'd like to discuss as an in-camera issue.
Do you think that's an in-camera issue? Well, let's go into camera.
Senator Eggleston might still have some questions.
Okay, well,
Rather than going
just excuse me, can I just ask the chair, through the chair, will we have an opportunity after we've been in camera to come back on the record?
Possibly.
So could you try and arrange some time for that? Because there might be some issues we don't believe should be in camera.
I'm trying to avoid going in and out, but to some extent that may be unavoidable.
Well, I, to be honest, Chair, I'm not sure what issues we would want to bring back onto the public record.
But there may well be.
There may well be. So maybe the sooner we go into camera, the better, maybe.
Senator Eggleston, do you have general questions?
No, I think to facilitate it's already 25 past. I think we should go into camera.
Okay, well, fine. Well, okay, we'll move into camera at this point then.